So I want to talk about the art of taking a killer deposition, and I've spent 25, almost 30 years taking depositions, and I want to share why it's so important and then some tried and true tips on how to take killer depositions. Now look, if you are a practicing attorney in litigation, only a small percentage, maybe 1% of your cases are going to be tried. And yet in almost every litigated case, you are going to be defending and taking depositions. Depositions and the skills needed in a deposition are the single most important factor in your success as a litigator. So when people ask me, well, Mike, when's your next closing argument so I can come watch? I'm like, well, you can, but I've been in practice for 25, 30 years. I've only done about 130 closing arguments. I do 130 depos a year. And those are the things that you really need to come look at. Now, there are some very, very important general guidelines that will significantly improve not only the depositions that you take, but how you present at a deposition. Remember that many, many times the deposition, even remote depositions, are the first time that you're meeting the other side. It is right after usually that first deposition, which is of the plaintiff or of the defendant, that the other side is writing a letter, an update memo to the carrier that sets reserves or maybe changes reserves, that gives an idea of the exposure of the case. They comment not only on the quality of the witness, but very importantly, the quality of the attorney. And so if you understand that is one of the two goals in a deposition, to get information, but also how do you present. You understand that if you know the law and then you know the art of a deposition, you can satisfy all needs of a deposition. So one, I try to take depositions as early as possible because the mindset of a deposition is not just getting information. It is also telling them what kind of leopard you are, what kind of litigator you are. And early depositions, I have found, convey strength, conviction in your case, that you're not afraid of the other side. So first, mindset is everything. You're not grandstanding, but you are pushing your agenda. You are saying, I am in control of this process and I am going to be the first out of the gate to take depositions. So as I say in my Trial Lawyer's Bible, I did a long video about taking killer depositions that's been very well received on my YouTube channel, Alder Talk. And I talk about setting depositions as early as you can. Don't wait for documents. Don't wait for more information, discovery responses. I have found way more often than not, you're getting good cross-examination before the other side has an opportunity to review those documents, because you may want to look at the documents, but if you're looking at the documents, the other side is also looking at the documents. And people that have a proclivity to lie will lie before they see the documents, but not lie after. And suddenly you have a veracity issue with someone who's not telling the truth because they didn't think you'd catch them. Secondly, preparation is critically important, but part of the preparation is to understand that depositions are only about 30% law and 70% art. But the law about what you can do are governed really by a couple of principles. The only objections that should be made, that are required to be made at a deposition, are form of the question objections. And that's because there's no judge there to rule on whether something's vague, lacks foundation, etc. And you have to raise it at the deposition so that you can give the questioning attorney an opportunity to rephrase, to fix something that wouldn't be ruled on until down the road. But if it's something that doesn't need to be fixed right there in the deposition, then there's not supposed to be an objection, and certainly not a statement that the witness should not answer. So relevance, calls for legal conclusion, etc., don't even need to be made at a deposition because they're not even going to be ruled on, nor are they waived if not made at a deposition until at the trial. In fact, the seminal case that in California is the most important deposition case, Stewart versus Colonial Western, S-T-E-W-A-R-T. By the way, if you spell a case, suddenly you look like you know what you're talking about. Try spelling a case to a judge. Spell a case to the other side. They're like, wait a minute. Not only do you know the law, you know how to spell it? It has gravitas. But what Stewart says is that it upholds the difference between form of the question objections, non-form of the question objections, and what a defense lawyer or a lawyer can instruct their witness not to answer. And Stewart says that unless the question calls for private information or privileged attorney-client work product information, they cannot interfere with the deponent answering the question. Now, the deponent may say, I don't know the answer, but you are entitled to every answer to a question that does not call for private or privileged information. Relevancy is not an issue in a deposition. It shouldn't even be raised in a deposition. Knowing what objections should be made that are waived if not, and knowing what objections don't need to be made and what you can get an answer for are critically important and basic foundation in pushing the envelope to get answers to many times the tough questions that the deponent doesn't want to answer. You're at fault. What did you do wrong? What did the other side do wrong? You falsified those records. You're lying right now. Those are questions that you can get an answer to if you understand Stewart versus Colonial Western. The second case in California, and there are similar cases in other jurisdictions, the Emerson Electric Company case, that's Emerson, says that in a deposition you can ask a deponent to act out behaviors and to draw schematics, draw the intersection, draw diagrams. And these are particularly effective as you're asking questions to elicit information and answers. And if somebody can't answer a question, then you have them draw it. It is not appropriate to refuse to draw because you're not a good artist, you're not a good drawer. You have an absolute right to have the deponent do the best job that they can, even if it's a crappy job, under the Emerson Electric Company. Knowing the law, which is 30% of a good deposition, apply that foundation now to the art of a deposition. You have prepared, and I'm going to talk about using chat or AI products. I use Clip, K-L-I-P, to help prepare for questions, issues, ideas to come up in a different way for depositions. But how you get your answers is critical. So pushing after a deponent usually says something like, I don't know, I don't remember, if they really don't want to answer a question, is really important. That push when they say, I don't know, and then you push them with, well, can you give me your best estimate? Can you give me even a general ballpark? I don't know. So you can't even tell me even the most general of ways. Many times, if they still won't answer the question, everybody in the room and every person on the jury understands that they probably do know the answer and it's bad for them and they don't want to tell you. You get that because you are able to push for an answer where you're not asking for private or privileged information. You have Stewart versus Colonial Western to keep the defense lawyer from interfering, and they either have to give you an answer or they have to look like they're avoiding an answer that they know. A very effective tool is to use your admonition as a sword rather than a shield. For decades, I have heard at the beginning of depositions, either side giving an admonition of the rules and the fear of, if I don't explain the process to you, then the 1% of the time at a trial where I try to cross-examine you on the deposition testimony, the opponent's going to say they don't understand. First of all, I'm 30 trials in, never happened to me ever. And secondly, it's a wasted opportunity. Try when the first time that a witness says, I don't know or I don't remember, to an answer that they really should know, right? Most people have never been sued before, never been in a big collision before. And now you're asking them questions. Suddenly they have no recollection of who they've talked to, what documents they reviewed to prepare, etc. And it's complete BS, because in a social situation, when they're not under the penalty of perjury, that's how we get away with not answering questions. I don't know. Hey man, what happened yesterday? Whatever. And they don't get forced to answer the question. So using the admonition at that time is a great way of refocusing and getting people to answer the question. So let me give you an example. I ask a question that the opponent clearly doesn't want to answer, but they should know at least generally the answer, and they say, I don't know. At that point, you do the admonition. Look, you just said, I don't know, I don't remember, to something that clearly I believe you at least have some recollection. And I want to talk about this process. The deposition is a legal process with penalty of perjury under oath obligations. So this isn't like we're at a social club, and if you don't want to answer, you say, I don't remember. In a legal proceeding under the penalty of perjury, you are required to give me all information that is not a complete guess. In other words, unless you're making it up, I'm entitled to all information that you have, even if you're not 100% sure, because this is a legal proceeding under the penalty of perjury. And in fact, it's most important when I ask you questions that you're not going to want to answer because you feel like it's going to hurt you or it's going to hurt your boss or your company. Those are the times that a legal proceeding under the penalty of perjury are most important. I've done that many, many times, and then I follow up later. I remember an elder abuse case where I had a nurse and I had given that admonition. And then later on, I'm going through the records and I said, the doctor falsified these records, right? And her response, just like most people's response initially, is, well, I don't know. And I said, remember when I gave you that admonition about if you even have any information, even if it's a tough question, because it's under the penalty of perjury, you got to answer. The doctor falsified the records, right? And as most people's response, the nurse said, well, if I have to answer under the penalty of perjury, I think he did. It is a way of, again, using the law and the art in a proper way to push to get answers. Very, very effective. Next, you got to read the room. If you're pushing too hard, back off. If you're getting too emotional, back off. A very, very common ploy to throw you off your game is for a lawyer to get in your face, to not follow the law, to not allow the answers. And you need to have the patience and the fortitude to do your best. But at some point, if the obstruction is too much, then stop the deposition and make a motion. Do not get into a fight. Do not get into a situation where the judge is going to be reviewing the video of the depo and saying both sides are at fault. You want to comport yourself. But again, you know the law. You know how to do this. And the law supports you pushing for answers on non-privileged, non-private information. The last thing I want to talk about is using AI. Nowadays, AI is obviously ubiquitous, but what a wonderful tool to help focus and refocus you on big ticket items, big issues that then you can use the tools, the law, the techniques to push to get answers on individual issues. I did a webinar that is on our various platforms about how to use AI, chat, clip, Claude in your practice today to really efficiently and effectively narrow issues, come up with questions, come up with ideas, come up with better ways to skin a cat. And it's very effective. So take a look at my YouTube site and my social media site. After all of this is done, the final thing that you need to do in an expert deposition especially is under a case called Kennemer, you have to see if you've left anything out. A good catch-all question in an expert certainly is, have we talked about all of the opinions, at least generally, that you're going to talk about at trial? But I suggest you do that in a non-expert. Have I now gone over every communication that you've had about this topic? Have we talked about every single time and every single person that you've talked to? Because you may have unwittingly narrowed your questions to a point where they are correctly answering questions but excluding. Go back with a catch-all at the end of a deposition so that you have that on the record, that if later on they start talking about other people and other witnesses, you at least have that catch-all question that says, have we talked about everybody that you've talked to, worked with, done whatever regarding this issue? And they can't come back and say, well, you never asked me that specific question. These are tried and true techniques. Now listen, I have literally a library of thousands of depositions that I've taken under any and all contexts on video. I have literally 5,000 expert depositions taken by me and other quality people around the state of every type of medical provider you can imagine. Trial transcripts with cross-examinations. It is accessible for the price of you asking for it. If you need anything, please reach out. My info is in the bio or the video description. Come on now, Depos.